Now, one person we did hear from today for the first time, Karen Read herself, doubling down, of course, saying she did not do this. She wants to know who did.
Said it feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life.
Yeah.
I tried to save his life at 6 in the morning. I was covered in the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she admitted to it.
No, she didn't.
That's not true.
She asked a question. She asked a question, which is very different. She didn't admit to anything.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Okay, how is everybody? Hi, Tammie. Hey, Dean. Patty Cat. Susan Hicks. Nice to see everybody. What a day in court we had. I say we. I wasn't there. But I was live streaming it. And the hearing was just jaw-dropping. I've had one similar experience at the NXIVM federal case, NXIVM hearing, where a judge got this. Well, he was kind of high-tempered anyway. This is not something we see from Judge Cannone, and I've never seen sanctions mentioned. So to bury the lead, what happened today in court is that the ARCA experts that we've all been told were so independent because they were hired by the feds to investigate. Well, anybody with a critical eye on the Karen Read case knew that Karen Read, through her connections, instigated that federal investigation to everyone who arrested her, got her, essentially, charging her with her crime. So we knew they weren't all that independent. But what we found out today is that ARCA was paid. They said they weren't paid by the defense. Were paid $23,000 by the defense. There were communications between the defense and ARCA. I won't say this if you don't want me to say. There were questions and answers given and expected answers outlined and given between ARCA and the defense. So they choreographed a whole big bamboozle, a tap dance in front of the jury. If anybody's seen Chicago, I would say this is a tango done by ARCA and Karen Read's lying criminal lawyers. And it also really exposed Judge Cannone because she, of course, was a defense attorney herself. And she could not have missed that every single defense witness, there's a pretty much almost, except Lucky Lawfren, there's a Rule 14 violation. How did the defense do a Rule 14 violation every single time? Meaning they didn't hand over the discovery because they didn't want the Commonwealth to have it, because they wanted to stack the deck in their favor. And this is why I say that Karen Read's lawyers can't be all that great lawyers if they can't win by playing fairly. A great lawyer doesn't have to bring in fraud, commit fraud to win their case. But here we have lawyers playing a game. Hey, we'll just not hand over anything to the Commonwealth. Then they won't know what we have, and they won't be able to cross-examine them. And in fact, in the rule, in the voir dire of Mr. Wolf, what a perfect name, Wolf in Sheep's Clothing, or Wolf in Snake's Clothing, the Commonwealth isn't even allowed to cross-examine. So, it was just a show put on, and I'm going to show you this in a little bit. I'm going to show you the voir dire and the conversation they had about Marie Russell, but it's really telling. And then a little bit of the voir dire of the ARCA expert, Mr. Wolf. So here we're going to have, before I do, I just wanted to show you the paperwork attached. Now comes the Commonwealth and requests that the Honorable Court impose sanctions against the defense for their repeated and willful violation of court rules and protective orders under Massachusetts, whatever act. Willful violation by counsel and violation of court orders shall subject counsel to such sanctions as the court shall deem appropriate, including citation for contempt of the imposition of costs of a fine. So the problem with a fine sanction is that the free Karen readers will just pay it off for Alan Jackson. That's my fear. They seem to have endless money to want to throw at this case, right? And they'll just pay it off. The purpose of this rule is to regarding the conduct of attorneys practicing therein, the court of the Commonwealth, and to discipline those whose actions fall short of accepted standards. This is long in coming. They've been playing games and basically committing a fraud upon the court in so many ways. Leaking information to Turtle Boy and then saying in their motions it was reported. Lying to the court, telling the court that Karen Read has a brain tumor. Other untruths, that they have proof that her car was in a different state than when it was photographed by the Commonwealth. On February 11th, as the defendants' motions to reconsider reciprocal discovery order, it appears that the defense flagrantly violated protective order previously agreed to by the defendant and set by this court on November 13th, 2024. In January 31st, 2025. The defendant's motion, it quotes a text message sent by Trooper Michael Proctor. This text message is subject to protective orders. See, I don't know why they don't impose a gag order. I don't think Hank Brennan is already under basically a gag order. If he ever gave an interview, they would accuse him of prejudicing Karen Read's right to a fair trial. I don't know why Judge Cannone also didn't put a gag order on Karen Reed, but I'm glad she didn't, because I don't know. It's been very helpful to her innocence fraud campaign, so maybe I take that back. Maybe I'm not so glad. This text message is subject to protective orders, and the January 31st, 2025 order specifically restricts the public dissemination of all communications, including those within the work cell phone of Massachusetts State Trooper Michael Proctor. The defendant attempts to unilaterally amend the protective order by claiming that only the screenshot of Proctor's text message is subject to a protective order. This is, so they're saying it's not the content, it's just the screenshot that was protected. Give me a break. This is an obvious, hold on, violation of the protective order. Further, the defense claims that the protective orders are limited to personnel identifying information is misplaced. Before communications were produced to the defendant, personal identifying information such as phone numbers were redacted. The purpose and necessity of the protective order, as stated, is to effectuate the well-established privacy and safety interests of witnesses and to protect the integrity of ongoing investigations. A reoccurring issue and concern in this case. Notably, this is not the defense's first violation of a protective order or court rule. The defense has repeatedly displayed autopsy photographs of the victim without permission of the court. Great point. There's another violation. Remember when Judge Cannone was like, put that down, after Elizabeth Little had kept it up for quite some time? So displayed autopsy photographs of the victim without permission of the court, and has previously filed motions with photographs and names of juvenile witnesses, photographs of victims' deceased body, and has released witnesses identifying information to include their names, date of birth, social security information, addresses, and phone numbers. And then they put the law further. This court ruled that it is unacceptable for defense counsel to misrepresent and distort facts in impounded documents and to fail to comply with orders of the court, all which happened in this case. The court will not tolerate actions by counsel which waste the court's times and resources or violate the rules. Therefore, the Commonwealth moves that the defense be sanctioned to include, but not limited to, being ordered to file all motions under seal and impounded until such time that both the Commonwealth and the court can expose the court exposure that the filings comply with all the previous orders by this court can ensure, that all the filings comply with all the previous orders by the court. The content of inappropriately filed motions serves to taint the prospective jury pool. Oh, funny how that happens. So this has been an ongoing issue with the defense. I saw today on X. Actually, I'll get to that later. I'll get to that later. Hold on one second. Sorry, my boyfriend just came home. And he's been gone for quite some time. I just had a few things to say to him. Oh, you hear him in the background there. There he is. Okay. All right. Back to our regularly scheduled programming. My life. Okay. I missed you too, honey. So there we go. So this has just been a repeated problem with the defense. And Judge Cannone could not know as a judge that there was a reason why they were violating the same Rule 14 all the time. Because they seem more than happy to have these voir dires, which were like mini show trials for their witnesses. So let's get into it. Before I get into today's hearing, and I will get into today's hearing, really the most fascinating part is at the end. Of course, Karen Reed's new interview that I went over last night's coming in. But more importantly, Hank Brennan was just on fire through the whole hearing, calling out the defense time after time for bringing in the Sandra Birchmore case unnecessarily and in a way to try to get more phone records of police officers so they'll have more embarrassing texts. That's what they're looking for. They want all these records. So let's look at. So this happened day 27 of Karen Reed's trial. We had a voir dire hearings with Marie Russell. So she just left. And this is just check out Judge Cannone and the way she treats Lally here with absolute contempt.
Excluded from testifying at the trial for the violation of Rule 14, specifically, I believe it's Rule 14A6. This is a witness, as the court picked up on, that reached out, albeit through an intermediary, with reference to just sort of discovering or coming upon this case in several weeks into the trial. It is concerning given the fact that the witness represented that she had a subscription to the Globe Online, received word of this, and the first time that she had ever seen it or it had grabbed her attention was in that first week of May when, as the court is well aware, there's been widespread media coverage, particularly through the Boston Globe, for years at this point. The limitations of the testimony, it's also concerning because the disclosure from counsel indicated, again, as the court had noted, I didn't want to get into too much as far as for purposes of this voir dire, but there was additional material that was indicated in the disclosure that the witness had reviewed, including the UC Davis related to the canine DNA or the lack thereof, as well as, forgive me, the dog bite history of that specific dog, which also I would note for the court includes photographs of what a dog bite from that specific dog looks like. And that specifically apparently was not provided to this witness, who's then opining on, inferably at least, that that dog was the cause of these particular injuries, however, was not
Right. So like this is what the basically the cross of Marie Russell was they had no cross because Alan Jackson wouldn't let Adam Lally take 2 bites of the apple. Why not? I mean, I'm not a lawyer, but this just seemed like it puts just by continuing to violate all these Rule 14 motions, they got to bring in their witness like a show trial. Like, hey, we'll ask you some basic questions, not go too far into it, And see, that's what she's going to say on the stand. Come on.
Middle of May, and to the point that the limited amount of material or information that's provided by counsel as far as disclosure opinion doesn't come until today. So for all those reasons, Your Honor, the Commonwealth is requesting that her testimony in its entirety be excluded from this trial.
Jackson? Your Honor, exclusion is the highest form of punishment. It's the highest form of sanction that the court has available to it. Just to put a fine point on it, it is a dire remedy. And I know the court has mentioned 2 or 3 times.
Well, it's not the biggest punishment we found out today. Alan Jackson could be thrown off this case. So he has a special pro hoc ticket to be able to practice law in Massachusetts, and they could rescind it. Your latex spouse. Excellent independent coverage, Roberta. Thanks so much. Monarch, thank you so much for the very generous super chat. Happy belated birthday to my birthday twin. Same birthday? Happy birthday to you. And it's my godmother's birthday too. Happy birthday. Thanks so much, Monarch. Nice to see you. What a nice surprise. All right, here we go. It's like that's the biggest, to not let her testify is the biggest sanction
Finding a
imposed.
violation of Rule 14. That sounds as if the court is suggesting or has inferred that we did something wrong. We didn't.
We did something wrong, like we intentionally planned to not hand over any discovery and told her not to write a report. That we'll just have a voir dire instead and we'll be A-okay. Because I think that they have Lucky Lawfren's testimony, I believe, was coached by the defense. He could have even been paid. There's so much fraud from this defense, in my opinion. Just my opinion. And also with Marie Russell, didn't write a report, which is very unusual for experts ahead of time. Nothing to hand over. She comes in at the last minute. Believe she definitely got coached by Robert Alessi this time round. Huge differences between her testimony last trial and her voir dire this trial. Or her hearing. It was really a hearing, this trial. Huge. Same thing happened with Richard Green. Huge differences in language. Hank Brennan's been bringing it up. He got wind of their game. But he's like, you're accusing us of doing something wrong here? We can't be punished. We did nothing wrong. I just found out about this witness the last minute. Is this story a true story? Love to talk to John Lewin about it. If Marie Russell did he really do this, or is this something that they made up? Did he really put Marie Russell in touch with Alan Jackson at the last minute?
Didn't do anything wrong. Because the court learned, I didn't reach out to her. She reached out and said, hey, look, I've got some experience with this.
I asked you that the other day, though, and I was told that you reached out to her through an intermediary. I wasn't told she reached out to you through an intermediary.
I don't know that there's a difference. I mean,
see, he's already lying. He's already caught lying here. Lawyers are very careful with their words. They can misspeak. And you'll see Hank Brennan misspeaking today in court. But when you're asked how someone, this is something that you wouldn't normally misspeak or misrepresent how you met Marie Russell. So I'm calling into question the John Lewin connection. Is there really a John Lewin connection? Did he reach out to Marie Russell and realize they had John Lewin in common, and he became the fall person? Certainly was no comment when I asked him about it.
What I was trying to get at, is this somebody who read about this case and said, I want to be part of that? That's what I was trying to get at. I think it was pretty clear, Mr. Jackson. Go ahead, continue with your argument.
Okay.
And she did. She's an attention seeker, and you let her testify anyway. She's wholly unqualified. Her interest is in police dogs, bite and hold, not a dog, just dog bites in general, and a methodology for identifying them. All that was developed by Robert Alessi, Karen Reed's new pro bono lawyer.
I did not misrepresent it.
I didn't say that.
I take a.
Oh, this is so street. When you do something, and you get really loud, and to put the other person on the defensive as if you're offended. You should see the video of Alan Jackson walking out of court today. No shame. Other lawyers would be running no comment. He is just walking down the street, no sweat off his back. But he also said he had to be there in person. I don't know if he will. He may be on a Zoom for next week's hearing when Judge Cannone rules on this. I'm sure she'll choose the softest sanction possible, if there is one.
Defense at the court's tone that yes, you did say that. You just said that. You said, I just heard the testimony, and it's not what I said the other day. I know a person in Los Angeles DA's office. I received a text message from that person saying there's someone who reached out to me who said I might be able to elucidate on this controversy concerning the dog bites. I then reached out to her. So when you asked me who reached out to whom, I reached out to her through an intermediary, my friend in the DA's office back in Los Angeles County.
So maybe it wasn't clear what I.
If Lewin is really friends with Alan Jackson, he needs different friends. Because this would be no one I would ever trust, just by the way he practices law. I wouldn't trust him with taking out my trash. I mean, I think he's so immoral, so sleazy.
I was looking for. I think it was clear. But go ahead, continue with your argument on this.
My point is, Rule 14 requires a sanction if, in fact, the attorney has done something wrong. In other words, it connotes the idea that we're doing something by actively hiding evidence or holding back evidence or not providing evidence that you're going to use at some point in an effort to take a tactical advantage. And the sanction for that is exclusion. I've never met this woman. First time I laid eyes on her was during the process after she flew out here to engage this voir dire process. She indicated I could potentially.
I've never met her. I've never laid eyes on her. I just wonder if any of this is true. See, this is what happens when you lie to the court and you misrepresent things and you play games. When you are telling the truth, no one will believe you.
Provide some information about this controversy concerning dog bites. I then sent her materials. I talked to her. I sent her materials. I found her to be incredibly credible. I found her to be experienced. And I found her to be knowledgeable in this very specific area, which is rare. There's not that many people who have published, doctors who have published in the area of dog bites specifically. So I thought it makes sense for me to reach out to her and talk to her.
No, there's surprisingly more experts than you think that testify on dog bites. But I'm sure none that you approached that would testify what was on John's arm was caused by a dog bite, looking at the totality of the evidence and knowing what they knew. And also, as I went over, I've been over this before, their criteria is to look at the dog to really understand the whole and look at the area that it was done. I mean, it's not done the Marie Russell way. And that's why it was so important for Marie Russell to testify that when she was working at the hospital, there were times when people couldn't tell her that they were bit by a dog. Either there was a language barrier. Apparently, no one in the entire giant hospital in California could speak the language of the patient. They couldn't go woof woof and point to the point to the wound. There was no way to communicate, and she had to discern that it was a dog bite to say that she'd had a methodology, not this looks like this. And as I've said before, there are a lot of things. A waxed apple sure looks like a lot like a real apple, but boy, try to bite into it, and boy, you'll find out they're different. So there we go.
Exactly what we did. And within a couple of days, literally, you could almost count it by the hours of me receiving her information. We then had a discussion amongst ourselves. Is this somebody that we want to then present on the defense side, on the defense case? And we turned the information over to Mr. Lowry. I understand that it was well into the trial, but that's not a fault of ours. And I don't think the sanction of exclusion is necessary or appropriate to punish Ms. Reed from having an experience with.
Right, but right after this, we have another hearing, another voir dire with the ARCA expert, Mr. Wolf. Amazingly, they couldn't hand over anything in time at all to the Commonwealth. And this was the remedy every single time. So this is why I say, Judge Cannone, you'll see her reaction. She let this fraud go on. She could not have not noticed that there was a pattern with their expert witnesses here to not hand over discovery. She could not have noticed it. She's been around the block. She's not a spring chicken. She knows the way the defense lawyers operate. She knows the advantages as a defense lawyer of not handing over, say, reports from expert witnesses in a trial such as this. And she aided and abetted it. And so she's been terribly embarrassed because her fraud has been exposed, not just Karen Reed's lawyer's fraud, but Judge Cannone's fraud. Because letting it happen is akin to making it happen. So, the voir dire is just a nothing burger, just to give you a little idea. So she agrees she's coming in. Here's Lally. Here's the way she treats Lally, just to take a listen.
Be out of bounds and excluded with regard to this witness. She's certainly a very experienced emergency room physician. So anything in relation to that, I think it's permissible. But as far as the experience when it comes to motor vehicle crashes or pedestrian crashes, of which the court is well aware, there are a litany of different types of interactions a pedestrian can have with a motor vehicle in a collision sequence. And simply saying, well, there was no injuries to the leg, so it couldn't have been a motor vehicle collision is just plain wrong, and not backed up by science or anything else that this witness can testify to from the very limited experience she has. And
Judge Cannone's been letting these witnesses come in. So she treats them with contempt. And then now it's time for the ARCA witness to come in.
Disclosure.
It is, but I have no problem editing.
So why is it on the disclosure or where the Commonwealth turned over that she viewed all reports associated with Chloe's bite history in the UC Davis DNA testing? Why is that in there?
Because we set that in a Dropbox. We set everything in a Dropbox, and I assumed that she reviewed it. She must not have seen it or opened it or reviewed it. I don't know.
Right, remember that? Right? She said she never looked at any of those things. She doesn't know how to work a Dropbox. She's too old. Again, caught in another misrepresentation to the court. It's the lawyer's job to make sure that she can open the files and that she reviewed them before she comes to court. So they're either lying, which was my first, and didn't show her anything because she's an attention-seeking turtle rider, essentially Marie Russell, or that this is their excuse. They can Dropbox these things to Marie Russell, but they have a hard time Dropboxing, say, an ARCA opinion report or the ARCA communications to the Commonwealth.
Everything that's in the disclosure is oversight.
Right. If she's permitted to testify, you led her through quite a bit today. You won't be able to. I mean, she struggled with to what degree of certainty she held an opinion. She struggled to what she viewed. She didn't write a report. I have to consider all of these things.
And she considered them all, and she said, let her in. And this time, Richard Green, the expert for the computer, so his opinion is so wrong that they had to rewrite the whole computer program. He's coming in. So now the jury has a second job. So they can't all agree that the earth is round. Now they have to have, because they've had a witness come in and say basically the earth is flat. Now they're going to have to argue in deliberations over the 227 the timestamp that doesn't exist, which is really 623 and 624. So they may argue over that. So that we may get another hung jury because of this kind of ridiculous. Karen Read has a right to have a expert witness, but not an expert witness who's just using wrong science that's been proven wrong, so much so that the program had to rewrite. So these kind of confusion of reading data would not happen again. It's just, we've seen terrible ruling after terrible ruling, bending over backwards to either what looks like Karen Read's defense team or the Karen Read mob, Free Karen Read mob. Hard to know which. But she's aided and embedded this fraud.
Things too, as the gatekeeper as to whether she can actually assist the jury. So I'm not deciding this right here. Mr. Lally, if I do permit her to testify, I will give you time to absorb this testimony and to find an expert in rebuttal for this. How long might something like that take?
Not terribly long, Your Honor.
But we saw no rebuttal expert really for this. Am I forgetting? This time around, we have Jim Crosby. Oh, Jim Crosby. I have stuff on him I have to get to.
As far as preparation, I can't give an exact time frame on that. As far as a rebuttal witness, I'd say a week at the most.
A week from today?
Okay.
Yes.
This is enough. This is enough. But so the ARCA witness comes in, and it's just a song and dance by the defense. Just to give you an idea, let me just put.
Fender bender collisions. I've dealt with collisions that involve 60-car pileups on a highway. So again, accident reconstruction in terms of the scope for a case, it can really vary case to case depending on the facts and circumstances of that case.
And when you say
we might come back to this,
dealt with, are you talking about literally going into, from an engineering and a scientific standpoint, trying to reconstruct what happened, what the causal effects were of that accident, and what the results were, the resultant damage or injuries were?
Absolutely.
So he's independent. He's not beholden to the defense. He's an absolute independent expert. Hey, Manny. I looked at LawTuber's most favorite Karen Reed. Thanks for the very generous super chat. Most favorite Karen Reed, and even they couldn't spin it. Dropped all jaws. Oh, you don't even know. Court TV pretended they couldn't figure out what went on in court. I'll play that clip in a second, Manny. They know how big this is. I think the pro Karen Reed streams are all bots too. 18K watching, commenting on live chat, the same messages. Bots. Love you and happy birthday. Thanks so much. Okay, so let me just show you this before I continue on to the hearing. Everything takes me longer than I think it's going to take. And I'm not sharing my screen. I'm sharing a file. I'm all over the place. Hang with me, guys. Thank you for your patience. So, okay. Let me just go home, go to my bookmarks, bookmarked it to show you. Yeah, here we go. Okay. All in order. Check out Court TV. What a bunch of fraudsters. Judge Beverly Cannone abruptly ended a hearing ahead of Karen Reed's murder retrial after learning information that gave her grave concern. Check this out.
Room in Massachusetts, the Karen Reed motion hearing. Judge Cannone brought the hearing to an abrupt close, saying the Commonwealth had just provided her with, quote, information that causes me grave concern and may have profound effects on defense counsel. She asked the parties to return a week from today, February 25th at 11 a.m.
Wow.
Wow, what is that?
And we were expecting this motion hearing to go all day. So what could she have learned? We know there were the arguments about bringing defense counsel on. There were discovery violations.
I think they're going to delay the trial. I think Alan Jackson, I don't know, he could be removed. I'm not sure. But whatever the penalty, she may forbid Arca from testifying. Whatever the penalty, I think we're going to see a delay. And that was obvious when she didn't let Alessi. We're on a really strict time schedule for an April 1st start. Give his presentation today. So make his argument today. So when she said, no, we're all going home. And luckily, Alessi is pro bono, but Karen Reed's got to pay for, all that lawyer time that these lawyers carved out for this hearing that just got scrapped by their own fraudulent behavior.
Violations that have been argued about inside of that courtroom. But she's learned something new that is not on the record.
Right. All right, we're going to head back to Cementelli, but quickly, Marie Pereira, your thoughts on Judge Cannone in stopping this hearing, saying, come back next week.
Why don't you get someone who actually saw the hearing to comment on it? They're like, we don't know what happened. Why don't you get word as to what happened? Their lawyers were setting up a song and dance between their supposed non-biased federal investigators, ARCA, hired by the feds, not the defense team, were actually hired by the defense team, and they scripted questions and answers. And then they wouldn't hand it over to the Commonwealth, thinking that this was going to be Adam Lally 2.0, and that maybe the ARCA would have to come in again and be voir dired. Just by the defense, not the prosecution, of course. Again, they don't mind doing that.
I'm on pins and needles because I would think that any abrupt news would have come from prosecution doing something that's of grave concern. But
right, we don't report on defense lawyers' fraudulent behavior. just the overreach of the Commonwealth or the prosecution here on court TV. A bunch of clowns.
To say that there was something said that gave her concern about defense, that maybe they found some dirt on the new defense attorney they're trying to bring in, pro hac vice. I don't know, but this is interesting to say the least.
Yeah, the terminology, she said it may have, quote, profound effects on defense counsel, which even...
They committed fraud upon the court. Fraud upon the court. Hey, Court TV, I'll do it for free. Right here. They committed a fraud upon the court.
Even not allowing this additional attorney to come in, I don't know if that would rise to the level in my mind of profound.
Sounds like someone's in trouble. Possibly.
Yeah, for sure.
Sounds like Alan Jackson, because he's the one in the communications. Hey, Alan, your voir dire was great. They're even talking about the voir dire. You don't want me to mention that most pedestrian accidents, where they get hit by a car, happen at night. That's not good. I won't mention that. That's not good for your case. They showed that they were incredibly biased witnesses, and they were orchestrating their testimony. So the why come has been finally answered. Why come, Arca said, and Arca was asked, could these head injuries come from a car? That was the question they had to answer. Not the rest of them. So why come Arca to answer that question, free Karen readers? Because they were in on the fraud with the defense. But what clowns court TV.
Yeah.
That someone violated some ethical rule. There is something concerning their licensing, their behavior, moral, ethical behaviors that are profoundly of concern. That is interesting because, I mean, so far it's always been the prosecution who's been accused of doing the dirt and hiding.
Right. Strangely, the defense, while doing all this illegal stuff, have been blaming the prosecution.
Discovery and Brady material and things like that. But to come out and say defense did some dirty deed that merits that harsh language?
They're shocked. They're shocked. They've been watching this case. So once again, very defense friendly court TV for the non-win. Hey, your latex spouse, do the right thing. Bev, Roberta, thank you for constantly calling out the lies in this case. Oh, thank you, your latex spouse. I love that. Oh, Donna, Wendy, when are we going to get to Donna's trial? Dean Walker, always so good to see you. Thank you. Right? All right, let's get into the hearing. Let's get into, and I may sort of skip past the beginning stuff because the end is so delicious and really get into the juicy stuff because we're already 48 minutes in. But let's see how it goes.
Thank you, Your Honor. My comments will be relatively brief. We filed this motion basically because we had no choice. We were following the court's instructions, meeting with Mr. Brennan after court the last hearing, which was the 6th, about the download of the video footage that apparently has been stored, or at least we believed at the time last week, had been stored on some sort of an iCloud. We were told that this was...
So Alan Jackson had to know, he handed over this material, he had to know this was coming, or something was coming from Brennan, or did he just think that he was headed for another voir dire of ARCA? Hard to know. Let me know what you think. But he starts out, once again, on the defensive.
It was an account of a retired detective, as explained by Mr. Brennan. We met after court. Mr. Brennan told us that we told Mr. Brennan that we did not need an expert to fly out and go through all the machinations of having someone present if all the information was a download from some iCloud account, unnamed iCloud account, as long as that was videotaped, we were fine with it. And that was basically the agreement. That was the information that we had at the time. We were predicating that on a conversation that we had with Mr. Brennan in January, I think it was January 22nd. He indicated that he went to Canton PD.
Of course he knew. So of course so all this stuff about this video now kind of comes into frame. So was this the distraction technique, knowing that this was coming with ARCA, to say, well, they've hid this video that we desperately need? Right? Is really just, we can never get it. And we can't get it the right way because, look, the Commonwealth is hiding evidence and destroying evidence ahead of what they knew was going to be an ARCA bomb. Right? Bomb on this case, giant explosion coming in. Isn't this interesting? The timing of this?
Same date, and the court will recall December 12th was the date of what I've referred to as sort of the wild goose chase, that we sent an expert out, etc. That same afternoon, apparently Mr. Brennan went to the Canton Police Department and found out that there was, in fact, additional video, which was news to us. He claims that it was news to him. And putting aside how odd that is, after 3 years of being told we have everything, he went on to explain in very specific form in a telephone conversation that he had met with a retired detective. At the time, he could not remember the detective's name. He said that the detective believed that he kept a copy of the January 29 video that we were looking for, and that he said that it was on a work computer's iCloud account. Mr. Brennan said that they intended to download it from the iCloud, turn it over, and that's the point at which we said, if you don't mind, just hold on that, because we're litigating ultimately this issue, which was the litigation we had on February 6th. So we had the hearing. The day after court on the 6th.
Does anybody care about this argument? So basically he's saying, like, hey, we need the data with it. We don't just need the video, we need the data. Because as I'm listening to this, I just don't care. Does anybody else feel that way? Does anybody else want to just skip to the good part? I'll go back if you want, but I'm done. I'm done with this. So he says, like, look, I don't know about data. The data's there. You know, you can have it. It goes back and forth here. Then I cut out. There is, I thought, Peggy O'Keefe looking really sharp. Not crying for the first time in court in a long time. Just seemed to be, the O'Keefe said, if you want to come, they're not standing in the way of them coming to see the driveway, and maybe looks like Karen Read might get an expert to say that the love tap that Karen Read did in the morning, early morning hours, 5:08 love tap, really could smash her taillight to smithereens. And they say, okay, through their lawyers, they say, come in. Okay, so we have all this back and forth about the footage, Karen Read making faces per usual. And there's a really great moment where Hank Brennan answers Elizabeth Little, who brought up the Sandra Birchmore case. And he says, why would you bring this up, right? I think this is the part. I hope this is the part.
Mr. Brennan?
The court shouldn't force reciprocal discovery. You shouldn't force it, Your Honor. Trial by ambush is simply that, trial by ambush. There were many instances when I reviewed this trial where the defense came up to sidebar, they had pictures, photos, things they didn't turn over that they expected to use for impeachment. And the rule requires them to do that. The reporter's note to Rule 14 talks about reciprocal discovery. Quote, even-handed discovery to both sides will improve both the administration and the delivery of justice. A witness has a right to look at information before their testimony. Just like the Commonwealth provides all evidence to the defense should do the same. Now, it's notable in the rules, although they're changing March 1st. We look at Rule 14A1A. That has a limitation in discovery for the Commonwealth under the person's direction and control. The reason for that is because the Commonwealth, unlike the defense, must provide all discovery in their possession and control. So, for example, if the Commonwealth is going to call an expert.
So how are these discovery rules changing? Does anyone know? Is there a lawyer in the House? Does anyone know? Massachusetts lawyer? Does anyone know how these rules are changing? Isn't it curious that these discovery rules are changing? Have defense attorneys struggled with these rules, and now in very defense-friendly Massachusetts, they're going to make it even easier for the defense and say it's not so necessary for the defense to hand over? Because I wouldn't think it would be on the Commonwealth. Are they stacking things in favor of the defense? That's something that I'll get back to you. I'll do some research and get back to you on.
They have to provide everything. Although the rules are a little bit more limited, it is the best practice to provide everything. If the Commonwealth is not going to call a witness, they still have obligations. And that is why that language is in Rule 14A1A. If the Commonwealth seeks consult with somebody, they're not going to call. They need to produce it to the defense. For example, I get random emails from unknown people, anonymous, or sometimes there are names on them, talking about theories of the case. I give it to the defense. Because it's in my possession, custody, or control. I have no intention of calling an anonymous person, but because I have the information, because I am the Commonwealth, they're entitled to it. If you look under...
I wonder who those are from. They're not from me, those... Hank Brennan, are you going to call Richie the plumber? Are we going to explore this plumbing issue that Karen Reed had on the night of the 28th, January 28th, 2022? Because I really think you should find out whether this Richie the plumber exists and whether he was contacted by Karen Reed on the 28th of January, 2022. You're doing a great job. Signed, Roberta Glass. There's going to be no emails like that.
14B, it's different for the defense. If they're going to call a witness, they have an obligation to produce evidence. If they have evidence they're going to use at trial, they have an obligation to provide it. And so allowing the defense to simply hide information because they think it's impeachment at trial is uneven-handed. It's not fair play. It's not in the interest of justice. There is no caveat or exception for the defense that they're entitled, in state court anyways, federal rules are very different, in state court for them to withhold reciprocal discovery. The order of the court at the first trial, even though it wasn't followed religiously, was that reciprocal discovery was an obligation of both sides, and that should not change. It's going to create chaos, it's going to create delay in the case, and it's going to create an unfairness. It will be trial by ambush. It will be. And so since there is no caveat or exception for the defense, and since there's no entitlement to withhold impeachment material.
That's what we had last time, trial by ambush, and didn't turn out well. We don't need to... Everyone but Lucky Lawford was voir dired. Oh, wait, I think they had one other witness who may not have been voir dired that I'm missing. But majority of the defense witnesses had to be voir dired because they wouldn't hand over discovery.
We should not make an exception for this team. They should provide it like everybody else. So I'm asking you to maintain the reciprocal discovery order that is already in place, and then hopefully at this trial, it'll be abided by.
Okay. Was there any follow-up to that? The motion for sanctions will be a little bit later.
Right. The only thing I would point out, Your Honor, is that with regard to the report.
Yeah, we didn't get to hear that. We didn't get to hear regarding motion for sanctions regarding Proctor today.
Of Jen McCabe, or Jennifer McCabe, I should say, revealing this link meeting. That report wasn't provided to us until after she testified. And I think this court remembers from the trial that there was sort of a rolling discovery that we received even as the trial was going on. So I just wanted to make that point.
Okay.
Your Honor, I've tried my best, and I will continue to provide all discovery timely to the defense.
Thank you.
I've been on the side where they...
So, right. So he's saying, look, I'm a defense attorney. So I've been really diligent about handing over everything I have. See, now the defense also can't point at the overworked, understaffed prosecution and say, well, they're doing it too. Certainly not any of those big claims where it was important.
Discovery comes in a trial, and I never want that to happen. Sometimes exceptions happen on both sides, but that is not the intent of the Commonwealth. The Commonwealth is doing everything possible to give the defense more discovery than they're entitled to as early as we can.
All right. Thank you. Next is paper 495. This is defendant's motion to compel discovery, and then there was a response.
So this is where I meant, but I'm glad I stopped where I did. This is where she brings up Sandra Birchmore case and all the officers that really aren't involved in the Sandra Birchmore case, but they are associating with the Sandra Birchmore case. And here I thought Hank Brennan's answer was compelling.
Request, I would look into any chain of custody information, and I did. I've spoken to a number of witnesses, including the retired sergeant, and I expect that I will have him write a report to give to the defense, and I'll provide them all the information that I have about what I could find out about the tapes that were provided in this case, where they came from, who downloaded them, who touched them, and who they went to. But there are some things the Commonwealth cannot do. They cannot simply invent a log when a log does not exist, and they cannot invent a chain of custody that is not in writing and there is no witness to. I've done my best to be thorough and diligent, and they will receive a report and have all the information that we have. It's odd that it's important during argument to mention that there's an ongoing federal investigation and then list a number of witnesses for the Commonwealth, implying somehow something's nefarious, that these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite onto. And so they just throw out terms and words.
Right, because Elizabeth Little's motion was really to the free Karen readers. They handed it to Elizabeth Little, which is what they usually hand their not a chance in hell of getting this approved motions to. But it's really to the free Karen readers. See, the feds are coming. The feds are coming. The feds are coming any minute now. Any minute now. All the witnesses in this case are going to be arrested. And it's like waiting for Godot. Like, it's never going to happen. It's the promise that will never be fulfilled by the defense. And like every great con, by the time that the free Karen readers figure it out, they'll be long gone on to another case.
For our audience that's here on our right, to try to create an illusion of impropriety. There is nothing that they have provided about the Birchmore case that will provide a basis for the Commonwealth to now go scramble and search for information that there's no good faith actually exists. It's easy to throw out a name and attach it to the Birchmore case, troopers, the DA, malign their name the way they know how to do. But when you're arguing a discovery motion, there must be a factual basis for it, a factual basis, a good faith basis. We hear the defense say that Trooper Garino says, nothing to see here. I have not seen that report where Trooper Garino says nothing to see here. I don't know what report they're speaking about when they suggest Trooper Garino had done something wrong in a different case. They imply it. They're suggesting that's the basis for you to compel discovery on a case that has nothing to do with Miss Reed's case. They just say it. And so you should reject outright an argument that tries to imply impropriety when there is none, with no factual basis or good faith basis, because they want to entertain our audience. And so the reality is the Birchmore case is being investigated by federal authorities. There's been a number of disclosures by the Commonwealth for information that has been public record. And there is no good faith basis that there is something in that case that is relevant in any way to this case. Ms. Birchmore was a victim. Number 4, unredacted copy of all reports, communication, handwritten law enforcement notes, again in the Birchmore case. Why? Why that case? Troopers work on many cases. That case certainly has a public appeal to it because of the harshness of it, the sadness of it. But what does it have to do with this case? Nothing. But invoking it is helpful for the defense. So they do. You should reject it outright, Your Honor.
Yeah, and I think she will.
Number 5, all communications, documents, reports, memorandum regarding Trooper Proctor administrative proceedings. Any information in the Commonwealth's possession and control, we would and we do turn over. In addition to what's in our possession and control, we know that there's likely statements that would be helpful for the defense, so we have an affirmative obligation under Graham. In fact, I had a conversation with defense counsel, and they asked if I would join them in a phone call and speak to counsel for the state police to try to encourage the production of materials in this case, whether they're exculpatory or not, even material irrelevant. And I agreed I would do that upon request. Now, that call has not been set up by the defense, but when it is, if it is, I will be there and I'll advocate for them for this information. In addition, there's a Rule 17 that has been ordered by this court that imposes an ongoing duty separately upon the state police. Now, state police have certain protection where it's an internal affair investigation by law. I cannot usurp that law. I can only earnestly try to my best of my ability. I sent an email on January 28, 2025 to a number of attorneys at the state police. And I informed counsel in view of the Commonwealth's responsibilities under Brady v. Maryland and Giglio, and most recently set out in McFarland and Graham, the Norfolk District Attorney's Office is inquiring whether the Mass State Police Legal Department and law enforcement officers assigned to the State Police General Headquarters in possession of any relevant materials, statements of Mr. Michael Proctor, witness statements, and any findings relative to the Department investigation and hearings relative to this matter.
Okay, I'm going to move on. I'm going to move on to the good part. Okay. So this is the good part. Okay, everybody, here's the mic drop moment. My apologies for it taking so long for me to get to, but there were some notable things in this hearing besides this, and I don't want them to get lost in the fray. I'm not purposely drawing it out, but I think that we have to put this in context of a pattern of behavior by the defense. And of course, the Free Karen readers are saying, because Hank Brennan misspeaks and says that he got this communication between ARCA and the defense from the feds. originally. And then he corrects himself and said, I'm sorry, I meant the defense. You can misspeak, especially in a hearing where there's lots of discussion of the feds. But Nurse Kim, who's a free Karen reader, is calling what she got out of this hearing was that, I'll get to it after, but that Hank Brennan should be sanctioned, which I found hilarious. Here's the good part, Audrey. Wait no longer.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an ARCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCA witnesses that I have the issue with. It's the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations, for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, and it was represented, these experts were hired by the federal government, and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are all...
Right. So do you see a pattern here? They say the ARCA witnesses we've never spoken to. We've never spoken to Marie Russell. We've never spoken to, what's the third witness? Was it Richard Green or another witness? Help me. But all to just sandbag the prosecution in this case, the Commonwealth.
Lined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. You know.
So TUI letters when you're trying to get information from the feds, federal government.
Over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence.
Right. I found that curious that did he say that, didn't he just say he didn't read the transcripts of the last trial? Isn't that unusual? Wouldn't you want to read all the transcripts of the last trial? Or watch it? Let's just hear that again. Or is he saying he did listen? I was talking to my girlfriend about it today, and she's like, no, he said he did. And I said, no, he said he didn't. Which is it?
The transcripts, I only have a flavor for the last trial.
I stopped at the worst part. Let me just try to do it one more time. Okay.
The very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a
Okay, my girlfriend's right. Okay. Having not been at the last trial. Thank you. Thanks, everyone. He just got a flavor from the transcripts.
For the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCA witnesses.
Curious also that he didn't watch the trial. Or did he do both? Did he read the transcripts? You know, I wonder if he did both, because, you know, you can miss things in expressions and subtle communications, nonverbal communications. But you can actually pick up on things that you might have missed just reading the transcripts.
Themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith, along with your retainer as required.
The retainer. $23,000 retainer. So they retained ARCA, talked to them on the phone so there'd be no record. But unfortunately, the ARCA wouldn't, you know, I mean, the craziest thing is when he brings up the voir dire, like, great voir dire you did.
Commonwealth, as I understand it, was not aware.
Thank you, Bossy. So Wolf is the ARCA expert. Is it Richard Wolf? The ARCA expert who I just played a little clip of. I mean, it's not an extensive, you know, voir dire. It's very short, and it's frankly pretty boring. It's, how do I say it? It's a tiny snapshot, excuse my slip, snapshot of what was done in trial. Tiny bit. So they really sandbagged the prosecution. They made sure they do this with every important witness.
Of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response: Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, It's not the opinion that troubles me. It's the relationship, and the Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications. I'll also attach my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary.
Feel free to edit my testimony. And this is C. Robert Alessi sitting right in front of Hank Brennan. This is what he did with Marie Russell. I believe he wrote her report. That's my belief, my opinion. I can't prove it. But Hank Brennan noticed the changes in language. Her report. And I think he did it with Richard Green, too. His report, they had 2 reports that they handed into with differences. The judge didn't know which one she should accept. This is the real corruption. And don't expect Court TV to be talking about this. This is the real corruption in our court system, done by these kind of innocence fraudster defense attorneys and, dare I say, innocence fraudster judges. I was looking at a case that Judge Cannone was a lawyer for before she was a judge. It's a case, excuse me for not remembering the victim's name in the case. But she was a little girl, 6 years old, and her cousin broke into his grandmother's house, essayed her, and killed her with her necklace. And Judge Cannone argued as a lawyer for this killer that he loved his victim and that he showed remorse every day. He was sentenced to a life sentence. But her opening statement, she said, we have to put emotion aside, that this case is so dark and horrible. But she, by letting this happen, she made it happen.
Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, 2 requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury to privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded, objective witness says,
these are so great, his dry comments. This fair, objective witness who knows no one, who we don't know each other, right? I had a comment, I think it was from watching the Whack Jobs, that Alan Jackson made a big deal of saying we don't know each other, we've never spoken, to the ARCA witnesses. I think they meant, hey, oh, there you are watching the Whack Jobs. Just were your ears burning? But I watched the voir dire. Was it in the voir dire or the and most of the testimony? It certainly wasn't in the beginning. You could send me a clip, or a timestamp, or leave me a comment of where I can find it. That would be helpful.
So not being able to inspect the vehicle is something that's not uncommon in your line of work, and he writes absolutely not, and then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue, I didn't personally inspect the vehicle, I had enough information from the material I reviewed, so it wasn't necessary, need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now,
So we have no idea when he got his testimony choreographed. I mean, so when Arca was testifying, it was really Alan Jackson. Arca would just say whatever the defense wanted them to say, like a dummy.
I'm not saying that undermines the conclusions of Arca, or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would it be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh. Don't tell them. Have you qualified as an expert in court before? Yes. I realized my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCA to the defense for $23,925. That's not Trimble.
And that's something the free Karen readers love to say at the trial. They can't say that they're a biased witness because they weren't paid for by the defense. Not only were they paid for, they were in bed with the defense, in cahoots. You know when you get those like a shirt or like something that says like materials made in America, designed in France. This was materials by ARCA, designed by the defense. They directed, choreographed their testimony. You don't want me to say that these things happen at night, which is hugely important because, of course, John O'Keefe was hit at night. I won't say it. No need to say that this is typical for a car accident because, you know, my testimony is that his head injuries weren't typical for a car accident. And even then, they admitted that in Cross that they couldn't exclude a car accident.
That's not trial by ambush. That's getting duped. So, I didn't know any of this, but I've tried a few cases.
Yeah, that's what I was going to call this episode, getting duped. We weren't duped. I knew there was something wrong with the ARCA testimony. But there is just a wealth of things that, you know, this is, I wonder how many times Alan Jackson has done this in other trials, withheld discovery and put his surprise witnesses on the stand to ambush the prosecution. I would say quite a few cases, if I had to guess. Who thinks this is Alan Jackson or David Yanetti's first time doing this ruse? And so that's why I say that Judge Cannone could not have recognized this ruse. It cannot be original. Lawyers don't do very many original things. There's very few original lawyers who operate in a unique way.
Around the federal court a little bit. I know how it works. And sometimes parties pick sides. It creates an imbalance and unfairness.
I don't know if the judge was duped. I think she had to know this was going on and let it happen, because she didn't want to be seen by the free Karen readers. And now she's been embarrassed. You'll see her reaction. She has a big ego. So she couldn't exclude Richard Green. I mean, the only reason to let Richard Green testify, well, there's two reasons, really. But I think the most important reason to Judge Cannone and Marie Russell both, the only reason to let them both testify is because to avoid the question, well, why were they allowed to testify in the last trial if they're unqualified? You had unqualified expert at the last trial. She couldn't be seen as allowing unqualified experts in the last trial, even though this is, as she's pointed out, Judge Cannone herself has pointed out that this is a whole brand new trial. So I think that the second reason is to avoid the free Karen Reed onslaught, chatter, and social media and the press that is basically made themselves, our press has made themselves aligned with this, with the Mansfield murderer, Karen Reed, is to avoid those kind of criticisms. She's very aware of her public image, Judge Cannone.
And then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens.
Casey, I've heard that argument. Hold on, Casey. You bring up a common argument. I think she wants no appeals loopholes. But it was way ahead of trial. This was not like last time where they threw Marie Russell in at the last minute. They had plenty of time to find experts. I don't think those are appealable grounds. I think they could have tried, but I don't think any judge would. They had all sorts of time to find new experts. And they knew that there were issues with Richard Green's testimony at trial.
I don't care if the witnesses testify at trial. I don't care about their opinions. But I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCA.
All right, I'm going to take a recess before the response.
Court, all rise, please.
Okay, so I just cut to when she comes back. And she looks visibly shaken. So note the shaking in her voice. And someone put in my comment section this morning, did she go out and speak to another judge? I mean, you really need a really wise, experienced judge for this kind of trial. And I don't think Judge Cannone's it, unfortunately. These Karen Reed's lawyers, and I think now Hank Brennan, know every sleazy defense trick in the book. And she's bent over backwards to accommodate them every step of the way. I mean, can you imagine being Richard Wolff testifying, knowing that your testimony has been co-scripted by the defense? in front of Peggy O'Keefe, who's weeping with a tissue in her hand, right, just right in front of you in this tiny courtroom, and you go ahead with it anyway because you want a paycheck and and your wife is a free Karen reader. So Richard Wolf's wife joined the Free Karen Read Facebook group 8 weeks after. Is it 8 days or 8 weeks after he testified? Very shortly after. All right, back to, here's Judge Cannone.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you. And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
So that's the information that the defense handed over. Here is Christina Rex's reporting on X with a legal analyst as to what Judge Cannone could mean by what she just said. Let's take a listen.
I would assume that she's considering revoking his pro hac vice. If
This is Catherine Loftus.
there was a misrepresentation on the record in open court, that certainly would be grounds to.
How many misrepresentations have we had, though? What happens to Yannetti when he says Karen Read has a brain tumor? What happens to Alan Jackson or Yannetti when they say the car was in total different shape than when Karen Read handed it over? the taillight had been damaged by, basically insinuating the taillight had been damaged by the police. So they get, I mean, they're like kids. Or criminals, really, these lawyers. You let them get away with a little bit and a little bit and a little bit and a little bit more and a little bit more. And then you have just these, one egregious violation after the next. Because all this was turned a blind eye to. We don't really need to. We can allow Aidan Carney to come into court after harassing witnesses. So witnesses have harassing witnesses in this case. Sit in the tiny courtroom. There's so many bad decisions in this case have been made.
Pull somebody's
So,
admission.
to clarify this for our viewers who aren't lawyers, meaning
Sure.
that the judge would consider basically revoking Alan Jackson's permission to be Karen Reed's lawyer in Massachusetts on this case.
That's correct. Because as an attorney, you can only practice in the court in the course in which you've taken the bar, or you've otherwise, sometimes after you've been practicing for a long time, you can basically swear into another court if you've been a lawyer in a jurisdiction for 10 years, things like that. Other than that, what happens in many cases, like Attorney Jackson and Attorney Little, Betterow, Attorney Alessi, they come from other jurisdictions. That doesn't mean they can't practice in Massachusetts, but they have to have the sponsorship of a local counsel attorney, who's David Yannetti, who essentially states, this person is in good standing in all of the other jurisdictions. They're here for a specific purpose. In this case, they should be allowed to work with the defense. I will ensure as local counsel that they comply with all local rules and regulations. And it's pretty pro forma. Pro hoc vice admissions are very regular, often more often in civil cases than criminal. But essentially, he's been admitted pro hoc vice, which means really the court is saying, okay, you can come in for this case, but you have to make sure you comply with all the rules. If you don't comply with the rules, the court has their own, it doesn't even have to be motion of the Commonwealth, it can be sua sponte, to consider potentially revoking that. And if there was the misrepresentation.
Right, but what happens if we only just heard a few of the communications? What happens if David Yannetti was working on this as well? What happens to him? Or if there's another kind of gross violation? I mean, it's not surprising to me. I mean, Alan Jackson is the biggest fraudster lawyer in Karen Reed's arsenal. Yannetti is a more minor compared to Alan Jackson fraudster, in my opinion. Though he's done some, I mean, both of them were in communication with Aidan Turtleboy Carney when he was doing the rolling rally, harassing witnesses, where they went from witness's house to witness's house, harassing them. They would say they were protesting, but calling them killers and etc. And I would argue, just by their silence, never telling the Free Karen readers to not harass witnesses, that they were aiding and abetting. From the filings in Aidan Carney's case, it seems that the Karen Reed lawyers were intimately involved in the innocence fraud campaign. So what happens to David Yannetti? My feeling is that when these kind of big issues come up in the case, they're just either swept under the rug. Remember when Marie Russell testified that Alessi had helped her with a report? That should have thrown her right out as a witness. And we could have seen sanctions for that, but nothing.
Presentation.
You can't write your expert witness's report
Of that information, I would think that would be a serious consideration that she's making right now.
Right, and given that Alan Jackson has really turned into kind of, lead attorney for Karen Reed's defense, that would be a pretty stunning consequence.
It would be a stunning consequence.
And I wouldn't be surprised, though, if this is just because this was done in public and everyone saw such a public way and dropped like a bomb in this hearing with the receipts. I wouldn't be surprised if we see Alan Jackson being removed from this case. If that happens, then we're going to see a delay because Karen Reed has to get a new lawyer. Apparently, Elizabeth. And what happens to Elizabeth? What happens to Elizabeth Little, who's from Jackson's office? Does she go too, or does she stay? And then what happens? Does Alessi come on? I mean, what are we going to do? We're going to see Robert Alessi's long drawn out cross examinations. But just while I'm here, I just wanted to show you about Richard Wolf's wife. Let me just get to my bookmarks. 1 minute, please. Here we go. Oh, here we go. Just let me share my screen. Wait 1 second. Okay. Just want to make sure. Sorry, this is taking me so long today. I've had a long day between the hearing and this. Not quite. Aiden Carney says, and this was June 27th, 2024. McAlbert Mafia, he calls it. Meaning the non-supporters of Karen Reed, is now sharing pictures of Crash Daddy, which is what they call Richard Wolf, wife and young children, because she joined a Facebook group after her husband testified months after he determined John O'Keefe wasn't hit by a car. It's funny that the side that, this is something else, but you can see here, Braden Carney, Dr. Wolf, one of Karen Reed's defense witnesses, is connected to the Free Karen Reed movement, Dana Wolf. You can see her there. I think it was 8 days after he testified, she joined. Now we know the answer. No, Jennifer Coffindaffer says, we didn't know, we barely knew the question to ask Jennifer Coffindaffer. Now we know the answer. Why was one of FBI's experts so adamant that their opinion wouldn't change without reviewing inculpatory information? Because of his connections to Free Karen Reed. His wife is in the Free Karen Reed Facebook group. Shame on him. So there is a connection between, you see a lot, at least stunning innocence fraud campaigns. They're often ex-FBI experts pop up. Jim Clemente is a big one. Along with Moore, I'm forgetting his first name now, both shilled for Amanda Knox, because of course they're out of work and they're looking for a paycheck. We saw some ex-detectives, ex-FBI, all those people come with heavy credentials, and they know that even if they've been kicked out of the FBI, fired or whatever, they can still use their FBI to make something fraudulent look legitimate. So I'm not surprised after seeing that the ARCA experts were acting improperly in this case, along with the defense attorneys. But if you've learned anything from this episode, I think I've shown is that there's a pattern with the defense. This was the defense's trick. Their trick to make their very biased defense witnesses look impartial and perfect their testimony and polish it up and get them to say what they wanted them to say. Money, editing their opinions, but mainly the trick was don't hand over discovery. Don't let the Commonwealth know. Say we just met, we just talked, you just came in, we don't know what they're going to say. Well, we're going to have a voir dire. It's like the punishment, born and raised in a briar patch, right? Briar rabbit, like, oh, not the voir dire. Oh, not the voir dire. What a terrible punishment. We get to ask them a few questions, and the Commonwealth gets to ask nothing. And the judge can decide to let them in or not. We know she's not going to do that because that's the heaviest punishment that you can do. Not so, Alan Jackson. I think you're finding out about the heaviest punishment. Anyway, it was a glorious day in court if you're on this side of the fence. Kathy Barella asked me, are you saying the defense told on themselves? They had to. They couldn't. Hank Brennan was relentless in getting that discovery from ARCA. They couldn't avoid it. They'd spent months avoiding it and running from him. Lally was, he didn't come with the kind of weight that Hank Brennan comes with in the court, unfortunately. He was, I think, really abused by the court, in my opinion. Talked down to, dismissed. I mean, won very few motions. I mean, the defense really won a majority of their motions. I mean, I'm not talking about some of the early ridiculous motions of the Commonwealth, but all those interviews of Karen Reed not admitted for what? I'm saying they had a pattern of deceitful behavior. They had a trick that they used. Don't hand over the discovery. Then push came to shove, and I'm sure they handed over the really damning documents amidst a flurry of unimportant nothing burger documents. Tried to bury it and hoped that maybe Hank Brennan wouldn't find it. That's what I think. Or notice. Or know that they told the court, because he wasn't here last trial, that they said they never met ARCA, never talked to ARCA, never talked to Richard Wolff. I mean, what a day. What a day. I mean, I went to a lot of hearings. I went to all the NXIVM hearings. Never seen a hearing like this. Explosive. Sometimes you learn evidence, that you didn't know in a hearing, but not something like this. I mean, this is basically, for me, it's the thing that I've been talking about through the entire case, which is that we have fraudulent, lying lawyers. And when are they going to, I think also Alan Jackson should be reported to the bar. David Yannetti should be reported to the bar. You don't have to be, anyone can report them to the bar for their behavior in this case. Because the more this is allowed, our court system will collapse under the weight of all this fraud. And every court will become a kangaroo court. And when it does, the movement, meaning the innocence fraud movement that created it, these innocence fraud lawyers, will step back and say, see, I told you all along our court system was no good. Well, they created it. They created the crisis. So that's what I think. That's This is something that I've been talking about, that Alan Jackson and David Yannetti et al., Robert Alessi, have zero moral compass, zero integrity, zero class, and that all that was exposed today in court. What a glorious day. I'll be back tomorrow at 6 p.m. Eastern. Have a terrific night, everybody. It was fun watching this again with y'all. See you tomorrow at 6. Thanks for listening.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mom. My innocence fraud campaign is my biggest hit yet. I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mark. My innocence fraud campaign is my biggest hit yet. John, you were my mom. My innocence fraud campaign is my biggest hit yet.